you can always, obviously, if there's an open record period, you can give it to me then, and I
Who's
can
gonna
open
be
record.
record period, I think?
So where is everybody?
Is appearance officer on Zoom?
He's on,
Oh.
he's remote.
But that's really interesting, because I didn't know that he was involved in Post. I love Post.
Yeah, it's beautiful out there.
I did a National Register nomination of a very special house out there, and that house is on the State Historic Preservation Office website. They love it so much too. It's very.
Is it out by the trading post?
You go to Post, you're heading south to Post, and then literally right at Post, you turn left on a dirt road, and you go up over the hill, and you get up on the hill and you look down this gorgeous valley to the east. Yeah. You have to go across rattlesnakes, across everything, and we almost run over them a bunch. And then at the far end of that valley is the house.
Is it being lived in?
Excuse me?
Is it being lived in?
Yes, 1893, Rover Ranch, and it's still, it was owned, at the time we did it, it was still in the Rover family in 1893.
That's interesting.
Yeah, the kids, the Rover kids actually built it, which is really cool.
Wow.
But anyway, then, the Rover family pretty much moved to California, and they wanted to sell it. And one of their grandmothers was my client partner on that, and she really wanted to save it. And then they found a buyer from Northern California who really appreciated its history.
Could someone in the hearing room let me know if you guys can hear me?
Yes, I can hear you, Hearings Officer Brooks.
Great. Is there anything else that needs to happen on your end, or should we go ahead and start?
I think we're all set.
Okay.
I can barely hear it.
We will then go on the record. The time is 6 p.m. and this is the hearing for Deschutes County file numbers 24722-573ZC and 24722-574PA, which both relate to a request for a plan amendment and zone change. My name is Tommy Brooks, and I am the hearings officer in this matter. We are holding this hearing in a hybrid format. So before we turn to the particulars of the hearing, I want to turn things over to Ms. House to describe how the electronic portion of this works.
All right, just getting my part one pulled up. So good evening. For the record, my name is Caroline House, and I am a senior planner with the Deschutes County Planning Division. So I'll start the hearing tonight by going over the hearing format and how persons interested in testifying can testify. I'll then provide a brief staff report. Then we'll transition to the testimony portion of the hearing. The applicant will provide their testimony first, followed by persons in support, then persons in opposition. The applicant will then be given an opportunity for final rebuttal, and staff will also have an opportunity for closing comments. So tonight's hearing allows for both in-person and remote participation. If you're going to testify, please, before you start your testimony, provide your first and last name as well as your mailing address. For anyone attending in person, Hearings Officer Brooks or myself will call each of you up to provide your testimony. Please make sure you're sitting at the table so we can pick up your audio, so Hearings Officer Brooks can hear you and we can record that as well. And then if you didn't sign in, please make sure you add your name to the sign-in sheet so I have that for mailing notices after this hearing. For anyone attending remotely, to testify, you must be attending via Zoom, and Hearings Officer Brooks will request that when we get to the testimony portion of the hearing for you to use the raise hand feature to communicate that you would like to testify. If you have logged on using a computer or a smartphone, you'll need to use the raise hand button, which is located at the center bottom of your screen. And if you've dialed in or called in, you'll need to dial *9 on your keypad to raise your hand so we know that you would like to testify. So if you would like to submit written testimony, that can be submitted to me. If you're here in person, please hand that to me. And if you're attending remotely, please email that. My email is my first and last name @deschutes.org. Staff and Hearings Officer Brooks are responsible for an orderly and respectful hearing. Anyone acting disruptive or being disrespectful may be asked to leave. And at this time, I'm going to pause and ask if there are any objections to the hearing format that was just described. And if you're attending remotely, please use the raise hand feature or dial *9 on your keypad. Anything? All right, so that concludes what I was going to cover. I'll turn the hearing back to Hearings Officer Brooks.
All right, thank you. And as Ms. House described, we're going to follow basically the normal hearing procedures that are in the county's code, and I'm going to provide sufficient opportunity for everyone to participate at the appropriate time. This application is being considered in part through a quasi-judicial process. I will consider only the factual evidence that is in the record. I will then apply those facts to any relevant provisions of the county's comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing the hearing. They are also set forth in the staff report. The public notice and the staff report are both posted on the county's website, and they are also available directly from staff upon request. It is important that you direct all of your testimony to the standards and applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to also explain why the criterion must apply and to do so with specificity so that other participants may respond and so that I can address that issue in my decision. Failure to raise an issue with enough detail that enables me or other participants to respond may preclude your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional issue or other issues relating to any proposed conditions of approval, with enough detail that allows me to respond to the issue in my decision, precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or any interest of any other participant. To that end, I will state for the record that I do not have any relationship with the applicant. I'm not aware of any connections that I may have to other participants in this proceeding that would prevent me from remaining impartial. I have communicated with staff, but only to discuss the particulars of today's hearing and not the substance of the application. I do not have any ex parte contacts to disclose. As Ms. House said, it's my obligation to preside over this hearing in an efficient manner. So I guess at this point, let's determine how many people are signed up to testify.
So right now in the room, we have the applicant's representative, Pat Cleaver, as well as a representative from Central Oregon Land Watch. And anyone attending via Zoom that's going to testify, can you please use the raise hand feature so we can confirm that you're providing testimony. So right now I see two hands that are raised. Both of them are associated with the applicant. So it's their soil scientist, Mr. Kitzrell, and the property owner, as well as their traffic engineer, Mr. Bestman.
Okay. Thank you. Before we begin, does anyone wish to challenge either my ability to hear this matter or to challenge the county's jurisdiction over this matter?
And I would request that if you raised your hand previously, can you lower it unless you have objections to Mr. Brooks presiding over this hearing? There's one hand still raised. So Mr. Rubert, can we elevate him? Wait, he just lowered it. So I think we're all good.
Okay, great. Then let's begin, and I'll turn it back to you, Ms. House, to deliver the staff report.
All right, so I have a pretty short staff report for tonight, but just for the basics, the subject property is located in the Deschutes Junction area. It's about 3 miles north of Bend along Highway 97. The property is approximately 20.36 acres in size and includes 3 tax lots. The applicant has requested a comprehensive plan amendment to redesignate the property from agricultural to rural industrial, and has also requested a zone change to rezone the property from exclusive farm use to rural industrial. And the applicant has not requested a Goal 3 exception, as the applicant's arguing that the subject property does not constitute agricultural land. For public comments, the applicant submitted, as part of their burden of proof, a number of letters in support from surrounding property owners. And the county also received one comment in support in response to the notice of application that was mailed out. Additionally, 2 comments in opposition were received. One was submitted by Central Oregon Land Watch. And just this afternoon, around 3, I think, 1,000 Friends of Oregon submitted a comment in opposition as well. That has been uploaded to the record, but I'm just noting for anyone in attendance that was kind of a last or a late submittal, I would say. And all of the record materials are published at the following website that's on the screen. And that's been listed in all of the notice documents as well as the staff report. And I can confirm that everything that's been received to date is currently uploaded to that system. And that concludes everything I had prepared for my staff report, but I'm available for questions from Hearings Officer Brooks.
All right, thank you. I do not have any questions for staff at this time, so we can proceed, and I'll ask the applicant's representative to begin. And it sounds like there's multiple people, so if the primary representative for the applicant could let me know how many or who you're expecting to testify kind of as your initial presentation versus who might be here just for questions, that would help me.
So, are Joe and those guys on there again?
Yeah, so if you,
There's Sam?
yeah, so
Excellent.
if you,
And Mark, too?
so Hearings Officer Brooks, Ms. Cleaver is representing the applicant. I will go ahead and ask for our producer to elevate Mr. Bestman, Mr. Kitzero, as well as Mark Rubert, who are all associated with the applicant or the property owner themselves.
All ready then? Good evening, Mr. Brooks and staff, and Carol McBeth is here. My name is Pat Cleaver, and I represent the applicant. I guess I'm the center of the hub here. The owner, Mark Rubert, I've been told is online, as well as Gary Kassoff, the soil scientist, and Joe Bestman, the traffic engineer. I am a little bit nervous. I'm stumbling right now, but I'll calm down. It's kind of my pattern. I am going to be sending some documents to Carolyn for the record, and just going to let her know what they are. One of them is a letter from Carl Jewell, and it has his photo, and unfortunately it has his obituary. He just died a few months ago, and he's an expert rancher, and he has some testimony about the inappropriateness of any livestock being raised or grazed at this intersection. And he's saying that that the animals could actually lose weight from the stress of 25,000 cars and trucks going down the highway per day. The other thing I realized was probably not in the record that as a hearings officer you're going to need are the tax lot maps for the surrounding properties. So I printed out, let's say 1, 2, looks like 4 tax lot maps, and then one I'm going to show in the PowerPoint is this diagram off the Deschutes County Dial website that shows the southern half of the site and the surrounding properties. So I'll give those to Carolyn now. Okay. So we're going to, this is a involved long application. We're used to small ones that have 10 minutes of testimony and you're done. But I was the planner on the Assetti case too, which I believe has become kind of famous in the state, considering the emails I get from attorneys. And I started that Assetti application, believe it or not, back in 2012. And so we've been working on that application for 10 years, preparing it and going through the motions. And it right now, it's in the record, the decision from just recently, that appeals court upheld Luba's approval of it, with no opinion, but we're still in the appeal period for Supreme Court. But anyway, so I've been living and breathing and studying this type of application for many years. So I wanted to start with a PowerPoint presentation, especially since you're in Portland, and let you see where the property is in relationship to other things. And then part of it is pictures of the property, most of which are not in the application. And then it ends with pictures of the surrounding properties. So hopefully we'll go through this pretty quick. The first image is of the center part of Deschutes County, showing Redmond at the north, where the 4 yellow lines, the highways come together, and then Bend at the south. And then on the right, there's a yellow thumbtack that shows where the last ranch is, so you can see where it's located. This slide shows you a little bit closer. It's more of the Deschutes area. The property is at the very eastern edge of a volcanic shield volcano called Long Butte. And Long Butte covers about 4 square miles. And not surprisingly, buttes over here, the volcanic buttes, don't just rise up out of the ground and be surrounded by beautiful farmland. The rock, the basalt rock from this shield volcano goes way out. And so not surprisingly, the land is very, very rocky. It's totally unfarmable on the butte itself. So the southern edge, the southeastern edge of the butte is on the subject property. And there's what we call over here a rock spine that goes for about 2 or 3 miles, pretty much along where the highway is. And the rock spine cuts across this property. You'll see that in a little bit. This is a little bit closer yet, and it shows the yellow line is the California Dalles Highway, Dalles California Highway, otherwise known as US 97. The cross street has so many names, and then I very thoroughly discussed the history of the road system there, because Mike Berry, our former county surveyor, said that there's more roads at this exact intersection than anywhere in the county, in the history of the county. And he drew up a diagram of all of that, and I'm sure that you'll look at it. It's on page 55, figure 19 in the application. You'll see there's railroad tracks on the right that are straight, and those were brought over from Portland. The railroad came in 1911. The oldest thing on that picture is the canal, the Pilot Butte Canal, this section was built in 1904. The canal was completed in 1905. The Dalles California Highway was not there then. There's even a closer one. By the way, all of these images are from Google Earth. The picture was taken last July 24th, just 2022. And you can see, start to see the parcel there where the yellow thumbtack is, and the surrounding properties. You'll see at the bottom of the property at the southern end are the roads that are going there. At Deschutes Junction, there's on and off ramps to the Highway 97 there. And this is even closer, and you'll see there's a tree line that goes through the property and goes, kind of curves up to the upper right, and that's where along the rock spine, there's a 19-foot drop just in that small space between the canal and the road, and you'll see some slides that show that the road is actually about 4 feet higher than this surrounding property. They built it up. But you can see a lot of mobile homes or motorhomes, campers at the bottom. That's at the Deschutes RV park across the street. This is even closer still. One of the most iconic landmarks in the property is that big heart pond there. It's left over from the Funny Farm. That was built around 1992. And then there's all those buildings there. You can see that this picture was in July and then middle of summer, and there's not much green. There is a little bit of green to the west or the left of the house, and we'll see that the water that comes under the road to the south is actually constantly, when the irrigation water is flowing, it's constantly flowing and running down the hill, and that's what causes that. This is a picture that you'll have to look at a little closer when you have time, but this is a ODOT picture from 1965 of that same intersection. And what I wanted to show, it doesn't look like I'll be able to with a pointer or anything, but the subject property is in the upper right. And you'll see that paralleling literally really close to the road there that goes off to the right, you'll see like there's a dark color, and that's water. And that's the little irrigation ditch that we've been talking about in our emails between me and Carolyn. So the water, you can see the canal. It's also very dark on the right, going up and goes north and north, heading north. And the water comes out of a pipe that's actually going into the canal on the south side of, which now Deschutes Pleasant Ridge Road, wasn't called that then. And it goes across, and then right beside the road, literally about 3 or 4 feet, it comes out of the pipe and runs down that hill, and you can see it's almost touching the side of the road there, and then it crosses over, and you can see both sides of the ditch that it crosses over underneath Highway 97 under the road and enters highway tax lot 500 there. That was when the highway was 2 lanes, and now it's 4 lanes. And so, the pipe has gotten longer, but everything's still in the same position there. So that irrigation ditch never goes on the subject property. This picture is, I believe, a 1994 picture. Again, right before the highway was widened to 4 lanes, and before the overpass was built there, which is the only overpass between Bend and Redmond, and all the new approaches and so on to that area, that whole transportation system is about to change. They completed it between 98 and 2000. I moved here in 1998. Actually in February, and we lived just to the left side of that image. We were in Starwood, and I know that I was doing, crossing right at grade there, which I have to admit was pretty terrifying. There were so many fatalities there. That's why they changed everything. This is an interesting picture. It is in the application, and this is a 1972. You would think it'd be like today, but no, it was way back in 72, before the county's first planning efforts were even accomplished, showing the lots that were actually in this exact spot. You can see the subject property between the Dallas, California Highway and the canal there and north of the roads, those are always fixed points, which is nice because everything else has changed. But you can see the tremendous amount of parcelization that had already happened at that point. And I comment quite in depth about this in the application. This is the entrance to the subject property off of Deschutes Pleasant Ridge Road. It's looking north. This is the driveway that you drive into. You can see the totem pole for the funny farm there and some of the buildings. Here's the driveway, end of the driveway, getting into the parking lot. You can see the distinctive 1912 barn from the Howard Ranch, which was 160 acres, and some of the other things. It looks kind of a mess, and it really was a mess. When Gene Carsey died in 2019, he had a complete antique shop, costume shop, all kinds of oddities there. And it all had to be sold, and the descendants and the inheritors were trying to sort it all out that day. I'm standing in the driveway looking to the west, and the cars there that you see are on Highway 97, and they're heading north. So at this intersection is the on-ramp to the northbound 97, and it's quite long. It's got a pretty good acceleration lane there. And the pink house straight ahead is on the Fagan's property. And you can see this shield volcano, in the far distance. It's the Long Butte. This is the actual place where the pipe comes out underneath Deschutes Pleasant Ridge Road, where the water comes out. You can see it's not very big. It's like 12 inches across, and it's has very little water trickling out of it. And then it splits into two. It goes down the hill like I've already described, but then this is actually going north into the backyard behind the residential, the main house at the funny farm, and it just flows. Nobody's doing anything to it. There's no gates, there's no nothing. The water, if the water's coming out of the canal, it's running back there. This is actually, I'm standing almost in the same spot. I've just turned the camera a little bit to the northwest and looking at the actual field that the soils report said has, resource soils here. It's about 2.5 acres. It goes all the way from the point right behind the house. There's a fence there. It goes over to Highway 97. That structure there was what they called the loafing shed for the goat that they had in their display. I believe the goat ate hot dogs or some crazy thing. But they said he wanted to get up on stuff, so they built up for him. This is, I took this picture way back in 2020, and it was a better year, and the water was dripping down there, and you could see some clumpy grass there. The ground seemed wet to me that day, so in all honesty and everything, I don't try to hide anything in my applications. This is the part of the soil that is what I would call a resource soil. And you can see the edge of the rock spine that behind it as the elevation starts to go up. That's just almost solid rock there. This is a picture of the Hart pond from the funny farm that's there. And Jean told me that at least 50 people were married beside this Hart, mostly on Valentine's Day every year. And that picture's looking, toward Long Butte. This is up above the rock spine. This property is bi-level. The top half is much higher than the bottom half below the rock spine, and obviously it's super rocky. People just picking rocks out and putting them in piles, and that's also where the trees are that's never been cultivated. There's no point to cultivate rock. This is a picture that you can see on Google Earth too, of a rock wall that was built. It was built, we think, about 1914, and it was built by the ranch hands for the Howard Ranch, which again was 160 acres, and this was the northern edge of the ranch. And then we're just going to get into some pictures of what it looks like there. I try to show you what every inch of it looks like here. But this picture, you can see the pretty abrupt change in elevation. This picture, I'm actually looking southwest toward Long Butte there. You can see that I'm up on the higher part. It's never been cultivated. You couldn't plow it if you wanted to. It's just old sagebrush and scrub and rabbit brush. This is a picture. I'm looking kind of north, a little bit west, behind the barn. And this is up in the basically flat rocky area, and the house that's there we think was the original house, probably from around 1912 to 1914. It used to be right at the corner of the road and the parking lot, and in 1991 when Gene Carsey tried to get a conditional use permit to continue his funny farm, which happened to be across the street until ODOT purchased land from the owner, and they had to move all these buildings. They ended up being too close to the road. His mother and father ironically owned the property across the street, which is the subject property. Anyway, the county told him he had to have a parking lot of a certain number of square feet, and the only way to do that was to move the house. So that's where that got moved. This is walking along the canal. The property, as you'll see, it includes the berms, it includes the land beside the canal, and it includes up to the center line of the canal itself. So 2.5 acres of the total acres are actually under the canal and in this easement. So you can see I'm standing up right beside the canal, and you can see how much higher, about 19 feet higher up there. This is what the canal looks like in the middle. It's much calmer at the southern end and at the northern end, but this is where you have about a 6-foot drop in elevation. This fence, there's actually 5 kinds of fencing, which the previous owners have done at various times, and they've tried to mark out the 50-foot easement here. It's really hard to walk through this area because it's just really wild up there. You can see the rock wall between, and the north side of that is lot 101, and the south side is lot 800. This is primarily lot 101, and you're looking up to a lot of the non-conforming uses on the other side of Highway 97 there. This is a photo. I was standing on lot 101 and just shooting as level as I can, and you can see how much higher they built Highway 97. This again just showing you the rock wall. This is the northwestern corner of the property. The trucks are right on Highway 97. And this is where the canal enters a pipe, a very large diameter pipe, and goes underneath Highway 97 and then heads north on the other side. This is back to the southern part of the property, and I'm actually in the driveway right now looking to the west. You can see some trailers and RVs straight ahead, and that's from the Deschutes RV storage that's directly across the street. Oops. So I'm still standing in the same place in the driveway, and there's a guardrail on the left, and that's right above the canal. And then Willamette Greystone is kind of to the right back corner there. Then right beside it is GP Energy and Aero, and then behind that, that's actually the dirt road going over to them to the right, and then behind them is the mini storage unit. This is a picture of Willamette Greystone, and that's just catty corner across the street. This is a picture of GP Energy and Aero. So this company, the GP Energy, has about 30 gasoline trucks that drive over to Portland and get loaded up with gasoline early in the morning, and then they bring it back over to Central Oregon and take them to all the gas stations and places that need the gas. So even though it has 30 employees, there is an office there that has like 3 or 4 employees, but all the rest of them are just driving the trucks back and forth. So this is a similar picture to the one I showed you. It just picks up the canal a little bit. You can see that. So now I'm actually standing on the Deschutes overpass, well, actually the approach to it on the east side, and I'm looking down on Deschutes RV storage. And if you can look at the horizon on the far right, you'll see the red Funny Farm barn right there. So it's literally across the street. This is a picture from 19th Street. I'm standing on 19th Street, which is the double railroad tracks. The Burlington Northern Santa Fe railroad tracks are right in front of me. And I'm looking into all the businesses I've been talking about: Deschutes RV Storage, GP Energy. I don't think you can really see Robinson's then, but the equipment in the foreground is from Robinson. So this is Robinson's, or 4R Equipment's headquarters. They own a lot of the land there and have, just like the other, they have lots of vehicles and things there. This is a little bit better picture of the first half of the mini storage unit. Since I submitted the application, this mini storage unit got doubled in size. So they've already built that up. So here's what was the back of it, but now it keeps going to the right. Here's some more pictures. Actually, I'm in GP Energy in their office on the second floor shooting out their window here. And you can see the barn for the Funny Farm. It's kind of on the left of the big yellow building. So this is, what's right there. This is across the street. This is due west of Highway 97, and the land that we call the Fagan property. It's tax lot 500. This is the back half of theirs. Theirs is 29 acres. And then this is looking due west toward the Cascade Mountains on Assetti's property. And the green storage building is on the left, and there's a bunch of containers on the right there. That's it. Okay. So can we put the other one in?
We'll switch it over.
I wanted to go over a few things. Today, I might need they've got another flash drive they're going to put in, but we got a letter this afternoon from 1,000 Friends of Oregon, and I wanted to tell you that kind of hit my heart bad because I have a very warm relationship with them. I've used 1,000 Friends, thank you, Cooperating Attorneys program 3 times and won all 3 times. The first time was with Bob Stacy, and the second time I actually got Ed Sullivan, and the third time I got Kirkpatrick, forgetting her first name. But we have a great relationship. I was actually named by 1,000 Friends to the Citizen Activist of the Year one year, which I was very proud of. And then my daughter Lori, with a mentorship from Ed Sullivan, became a land use attorney from the University of Oregon.
and she worked for 1,000 Friends of Oregon. And we have lots of social connections there, but they've always been way up on a pedestal for me, and really, they represented Oregon's land use system to me, and all of them, Mary Kyle McCurdy especially, and Robert Liberty were part of my mentors that I was so proud of, everything I learned from them. So to have them oppose me, all I can think about is this has got to be a mistake. So hopefully I'll be able to dissuade them. But one thing I do in my applications is I try to actually do a complete chain of title on all of them so that we can really look at what we're dealing with, how the land has been used and why over time, clear back to when it was owned by the U.S. government. And in Central Oregon, that usually goes clear back to about 1905 to 1910. Not as far as the donation of land claims in the valley by any means. But anyway, I think 1,000 Friends has made a mistake on that, because if you look at the section on property ownership, you'll see, a complete chain of title and a description of each party who owned the property and how they used it. And one thing you'll notice is that the subject parcel ended up being part of the Howard Ranch, which was founded in 1911. It's the first private party to have it. And it was 160 acres. And in that section of the application, there's a map my husband drew. He's a civil engineer and expert at using CAD. So he drew a beautiful photo, actually a diagram of the Howard Ranch, and it's a long, skinny, perfect rectangle. And it starts on the east side of the railroad tracks, which had actually just been built. That's why he bought that land for the ranch. And it goes all the way to Long Butte and includes the Fagan's property. It includes the ODOT quarry there. It includes Brenda Chapin's property. And it includes where Highway 97 later was built. And the subject property goes up the hill, across the canal, across the railroad tracks, and all the way. And Howard's house is still there. I have a picture of it. Family owns it, just loves it. And then the Redfield, who was the actual engineer for the Pilot Butte Canal, his house is still there, and it is still really loved. And so anyway, so they talk about how the buildings there prove that this is farmable land. They don't prove a darn thing other than the fact that the barn, the equipment shed, and the house we think, we have lots of evidence, were built in 1912 on a 160-acre ranch. And it was used as a stagecoach stop there, as was the house itself. And that doesn't mean that this piece of land was ever used for anything other than to put those buildings on. All the way up to the point where I have that nice picture of Mr. Leap, and up in Montana on his real cattle ranch. But when he bought the parcel, it literally stopped on the east side at the railroad tracks, but it went all the way over to where Highway 97 eventually crossed the land. And they, at that point, he also owned a second ranch exactly a mile south of this one. And so how did he use this particular property? He used it to put his livestock where he could go over to the railroad, and he loaded them on the railroad there. So anyway, then that land got cut back, and it actually now is 12 different properties in the Howard Ranch. And this property got down to just lot 800 at one point. It was just I believe 12 acres there. And then eventually when the land up above it the dairy farmer who lived was over a mile away. When he passed away, his daughter didn't need all that land. In fact, they'd never used it, the law 101. And then in 1991, she sold just that parcel because it was, framed by the Pilot Butte Canal and nobody could use it anyway, to the family that owned it then, the McNeelys. So anyway, so their assumptions here would be great if it was still the 160 acres, but it's not. Also, 1,000 Friends talks about the Goal 14 exception, which also hit a bad nerve with me, because when I applied for Tony Assetti's application, my pre-application meeting, the county staff said, well, Pat, you've got to ask for an exception to Goal 14, and I don't see in your outline that you're going to be doing that. And I said, no, sir, I'm not, because you only need an exception in certain circumstances. And one of those is if you're going to apply to put an urban use on rural land, and we're not going to do that. And he said, well, you're going to have to do it because I'm not going to consider it a complete application if you don't. So I took a breath and said, okay, already. So I did it. And the first LUBA case, which you have a copy of, says that you don't need a Goal 14 exception unless you're applying for an urban use on rural land. And they got remanded to take that out. So we took it out. Anyway, so she's back to this Goal 14 thing again, or he is, and there's plenty in the record, in the SETI case files about the Goal 14 wouldn't be necessary here. So just wanted to say those will probably be, I'll probably be writing a response to that, in the coming days. So I wanted to just go briefly a few things, because I think the application is pretty complete and shows that the applicant meets the criteria to get approved. And this application is only 190 pages, and I say only 190 pages because Tony's application I did was like 350. And so what I did was I went through what the hearings officer thought was important enough to include in the decision in both SETI 1 and SETI 2, and I cut out all the extraneous things. One of the things that the staff mentioned in her staff report is she wanted you to determine how far away from the subject property is an appropriate distance for surrounding properties. And I think that comment was interesting because on a SETI 1, I think I left it in for SETI 2, I had 3 months of research on surrounding properties in there where I literally printed out every dial for information for every property within almost 2 miles. And over a 3-month period, I literally went to visit them, took pictures of them, and if I could talk to the owners, I did. It was a huge, huge effort. And then I put all the data and all the photos in a huge table. And then I found out that you don't definitely have to go that far, that the hearings officer was just looking literally at surrounding properties. So that didn't quite meet my definition of a surrounding, because I realized that one of the state laws is to protect agricultural areas so that you don't want to have a pocket here, pocket there that's not resource zone. And if by doing so you make it really harder to be a farmer or a forester, you don't want that. So you want to have big hunks of agriculture, big hunks of forestry. And I talk about that quite a bit in the application. But so I figured, because of knowing that I needed a bigger area. So if you look at the document, you'll see where I'm actually talking about several miles away to the south and to the east, to the north. And then I talk about all of the application talks a lot about Whispering Pines, which covers 3 square miles of the Long Butte itself. And I was going to look at a few things here. It's hard to see. The screen's so far from me, I can't really see what's there. But Whispering Pines is described on page 129. And so Whispering Pines was developed in the late 60s. I actually have the actual date and all the phases of it, but it ended up being like 1,059 lots. And so that's a huge number of people that live up there, and some of it's still being built on today. And then, let's see, on page 47 is let's see. On page 47 is a complete accounting of all the residential development, which is a huge number. I'm going to quick look that up for you. So it has 1,900 lots. Residential lots had already been platted in before the planning period, before 1978. We already had 1,900 lots platted at that time. There's a map right above it, actually aerial photo, that has streets on it that was prepared by Deschutes County in 2020. And that, if you blow it up on the screen, you can see all the names of all the subdivisions that are on both sides of the subject property, west, east, and north, especially northwest. But it talks about Whispering Pines having 1,095 lots. Boonesboro, which is to the southeast, has 187. And then Centralo itself had 465. So in the history section, you'll see that this Deschutes Junction was really unique for another reason, that in 1911, the plat of the city of Centralo was approved by the Crook County judges, that it was going to be a town at that point. There's some remnants of it, but when the headquarters of the irrigation company became a district in 1921, and when the district moved to Redmond, a lot of the residents of Deschutes went with them. And Centralo was never called Centralo, it was always called Deschutes. So you'll see that. So the Howard Ranch map I was talking about is on page 79. You can take a look at that. So at this point, I think I'm going to take a little bit of a breath here, and I'm going to call on oh, wait, I know, there's one other thing I had to do before that, I'm sorry. So right in the beginning of the application on page 5, called the summary, section 3, I have I've gone through the major criteria, and, I've just gone, okay, boom, 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 this is how it is. So we have I'm going to call on the soil scientist in a minute, Gary Kitzrow, but he found that it is not agricultural land, and it's 66%, 13.44 acres is capability class 7 or 8, whether they're irrigated or not. And the lot 101 has never been irrigated. Most of lot 800 but none of the upper portion of the whole property, which is half of it, has ever been irrigated. There's no point in irrigating rocks. The area right below the house, about 2.5 acres, has been flood irrigated, which is pretty inefficient, but that's the way it was. And then there's no Goal 5 resources of any type on the property. There will be no need for urban services to be brought into the property. We have well-served letters from Avion Water, which I have at my house, and I'm in the country too. My daughter has at her house. They're a big service provider for the rural area over here. We have all of the power. It's already served by Pacific Power, and so that's all there, all of those. And then the transportation system was analyzed by Joe Bestman, traffic engineer, and it was determined to be adequate, which I thought was a big duh, because this exact location has more traffic going all around that poor property than anywhere in the county, and more roads than anywhere in the county. It's far enough from the UGBs to meet that correct qualification. So, you know, it's basically, I think that's a good place to stop for right now. And we'll switch it over to Gary for the soils report.
And Gary, you're already a panelist, so if you just want to unmute yourself and turn on your microphone, you will be able to present. Gary, I can see your hand is raised, but can you try to unmute yourself? It should be, the unmute button should be in the lower left-hand part of your screen. Could we try to unmute him for him?
Gary, if you just hold your space bar down, it unmutes you.
Gary, you should be unmuted now. You look like you're unmuted on our end. Is it possible for someone else from the applicant's team to present while Gary's maybe trying to work on his audio? Is there anyone else besides Gary who's presenting, since he appears to be having technical difficulties?
You can go to Joe and then go back to Gary.
Why don't we do that?
Good evening, hearings officer, Joe Bestman, traffic engineer, Transite Consulting. I'll be very brief because I think it was already touched on by Pat, which is that we assess the transportation planning rule for this rezone, and it shows everything complies. So pending your questions, I won't belabor the point.
All right. Thank you, Mr. Bestman. I don't have any questions for you.
Thank you.
Do we think Mr. Kitzrow is able to speak now?
On our end, his audio is unmuted, so we should be able to hear him. I don't know if you have an alternative headset or a set of headphones that you could maybe try to change your audio settings on, but it shows on our end that you're unmuted.
These are Gary's phone numbers if you need to call him.
We don't have the ability to call him. He could call in.
Oh, we did last time.
Gary, if you might try to log out and log back in might be a suggestion. We can always come back to you maybe later in the hearing, assuming that's okay with Hearings Officer Brooks, or I can defer to you at Hearings Officer Brooks if you have other ideas on how to deal with this issue.
Yeah, I mean, I would like to keep this rolling. I don't know what Mr. Kitzrow's testimony is going to be, so I mean, I definitely want to give the applicant the ability to present their full case. Is that it for the applicant's representatives that are going to be speaking?
Is anyone else speaking?
Joe.
Joe already spoke. Joe spoke.
Yeah, call on Joe, he'll do the traffic.
He already spoke.
Oh, he's all done?
Yes.
I was like waiting. Is Mark gonna talk? So Mark is there, you can ask him if he has to speak.
Okay, so Mark, we will unmute you now, and you can provide your testimony.
Okay, well, Gary and Joe and Pat are the ones with all the expertise in this matter. I was going to come last and just kind of take notes and summarize. What I can tell you while we're waiting for Gary is I went out there and dug all the test holes for his soil reports. It's in the record in printed matter what he submitted. Basically, there's 4 to 6, 8 inches of soil over solid rock on most of that place. The very south end, we found a couple places that were good ag soil, but it probably only encompasses half an acre or an acre. So the place is definitely non-agricultural land, as he showed in his report. I've tried to lease it for agriculture or animal use ever since I bought it, and even offering it to guys for free. I haven't had any takers. Nobody wanted to try to use it for any kind of farming purpose. As far as a standalone operation, it's way too small to be economically viable. It's surrounded by commercial use to the south and to the west, as Pat mentioned there in the photos. The place does have excellent road access, and it complies with the county's goal of grouping commercial areas together in spots that are not agricultural. I'm not just somebody that's trying to develop a place. I actually was on the other side and partnered up with Carol Macbeth and a couple of opposition, a couple land use applications back in Cook County years ago. So I'm trying to do what's highest and best for this property and comply with the Oregon goals of leaving agricultural around agricultural.
The second thing on that.
Oh, I think I heard a squeak. Is it you, Gary?
The second thing that you just showed you. It says that it's on.
Gary, we can actually hear you now. Are we here? It appears maybe a phone conversation. Can you hear us?
Yes, I can hear you. I apologize for the technical. Can you hear me now?
We can. We're in the middle of Mr. Rupert's testimony, so I'm going to let him finish, and then we'll turn it back over to you.
Okay, thank you.
Yeah, I don't have a whole lot more to say. Once Gary's done and everything else, I might put my hand up at the very end and try to summarize a little bit more. I'm not the expert in all the legal issues and what you need to hear. So I'd like to turn it over to Gary and go with the expert testimony for now, if that's all right.
Okay, thank you, Mr. Rupert. We'll, Mr. Kitzrow, you can begin your comments.
Yeah, I apologize for the miscue. Like you said, I was coming off of a different system and tying in. But anyway, my name is Gary Kitzrow. I'm a 30-plus year certified soil science soil classifier. I'm a former USDA NRCS soil scientist in the state of Oregon. And I completed the benchmark, or what the standard we're using up here for agricultural capability, et cetera, is called the National Cooperative Soil Survey. It's the same in all 50 states and Puerto Rico, and Oregon subscribes to it. And so all acres that I have tabulated or delineated or accrued in the state of Oregon while a soil mapper and soil taxonomist has been under those guidelines and auspices, including this property, the subject property. So what I wanted to do is just preface a little bit my report that was submitted under the guidelines of the OARs to the to the DLCD in Salem, Oregon, regarding the protocols in order to do a plan amendment zone change from EFU to, or such as EFU to some other taxonomic unit as far as land use. And so my job, as an NRCS USDA soil scientist on this subject property, etc., was to map order 3 detail. And I apologize for the complexity and the semantics here, but it's important, it's critical to understand and differentiate between the USDA NRCS scientist mapping of this property, which versus my current property that was approved through the state as a concurrence, and you have that in your records. So to stipulate, the USDA original mapping on this property was order 3, and it was for general land use for farming, ranching, and timber operations. It was not designed nor inferred to be used for land use decisions or zone changes, etc., because there's not specificity. This is a very small land base. And so, you know, the chances of a scientist being out here and doing the detail work I have done recently is just not really feasible. But I'm just trying to show the distinction between the order 3 that on the 1,000 Friends letter, which I'll get to in a second, they stipulated that it was, you know, whatever they stipulated to. What I'm trying to say is that the order 3 survey is a general premise for depending on the county and the geomorphic surfaces, the geology, et cetera, climate. And in this particular case, and in others where there's a plan amendment zone change, the OAR stipulate you need an order 1 soil survey, which is a high confidence interval soil survey that has specificity, meaning you can testify to precisely what's not on the landscape, not what is inferred or interpolated by aerial photography, with or without field verification. In this particular case, and in others that I do, and I've done over 300 cases in the state of Oregon, and then that excludes my NRCS soil mapping, which tabulated almost 500,000 acres. But for this subject property, we completed an order 1 soil survey with a specificity or a confidence interval, meaning we can validate it down to about 1/2 acre. Whereas the original order 3 soil map done by the USDA NRCS by my cohorts and my associates was down to about a 5 to 10 acre confidence interval. So this is very narrowed down because of the finite land base and the fact that this is actually a plan amendment zone change, and the DLCD actually formally requests and requires an on-site and field investigation in order to determine the efficacy of the soils, therefore the capability for farm and or forest production. So I wanted to make sure it's very technical, but it is important. So giving that, our confidence interval, the on-site, and we dug a lot of soil pits and did, according to the NCSS, which is a National Cooperative Soil Survey, same in all 50 states, same standard, we determined, quantified the fact that 66% or 13.44 acres of the subject property is made up of capability class 7 and 8 soils. And 7 and 8 means with or without irrigation. I do understand, and I acknowledge that in tax lot 800, there's 12.5 acres of irrigation, to my knowledge. And in lot 101, there's 1 acres of potential irrigation available. But The critical thing is the efficacy of the soil that's present with the use of artificial supplemental water. And there's a benchmark table that's in the National Cooperative Soil Survey, USDA, that was specifically made in Portland, Oregon. And this is ORNASIS Guide 1, revised June of 1977, pertaining to only Oregon soils. And in that stipulation and in that table, they specify that class 7 and 8 soils do not improve enough with artificial or supplemental water to become a commercial farm entity. And this is really important. It's very confusing, and I apologize for that. But being a former USDA NRCS soil scientist, I can testify to this is the protocol as a scientist for the government and as an individual consulting soil classifier and soil taxonomist. But I would like to briefly just respond to the Thousand Friends letter dated March 21, 2023, regarding comprehensive plan amendment and zone change, file number 247-22- et cetera. And I wanted to say, it said in the first paragraph, says the applicant has not proven that the property is non-agricultural land. So if you go down to on that, and you don't have that maybe at your fingertips, but I'm going to tell you, quote them on what they said here. Down 3/4 of the way in page 1, it says, first, the subject property is classified by the NRCS as exclusively class 1 through 6. That's a total false statement. The soils that was listed on the soil map, which is included in the DLCD letter of concurrence and soil release to Deschutes County, it quantitatively says and specifically stipulates that the original Order 3 soil map had capability class 3 through 7. And again, the difference is between the class or Order 1 versus Order 3 is that the Order 3, the publication of the soil maps was diffuse and broad, and they wouldn't get these small artifacts of the rock outcrops and the difference. But it's important to note that even the NRCS on their Order 3 soil survey showed there's capability class 7 soils, naming Gosney, G-O-S-N-E-Y, is the subject soil series present. So that's important. So that was a false statement that was presented by the Oregon Thousand Friends in their retribute of the findings. And then they go down in that same paragraph. This is important because I've seen this before in other testimony. The property, agricultural land, as a matter of OAR 660-033-020, any supplemental soil analysis only adds details to this classification. It does not replace it. That is an absolute falsehood. It is right in the OARs. It's explicitly and quantitatively explicit that if you go in and do an Order 1 survey, which is required for a plan amendment zone change, which the landowner here in this case is absolutely to the letter of the law, followed that. We are not supplementing the NRCS work. We are actually quantifying exactly what is on the land surface and in the soil. So in this case, the class 7 soil is one of them is Gosney. And of course, we have class 8 rock outcrop, which was not displayed or stipulated in the NRCS original Order 3 survey because the publication scale would not allow for it. And this is important, and this is a consistent, confusing issue that's been done in many counties. I've done this type of work in 15 counties in Oregon and had approvals all the way to plan amendment zone change for different, to industrial, et cetera, even just single family dwellings. But the statement, again, I'm going to read it. It says, any supplemental soil analysis only adds details to this classification and does not replace it. And that's an absolutely false statement because it's in the OARs, it's in the USDA NRCS stipulations in all 50 states that if we go out and do a very high confidence interval soil survey, we can verify or improve or replace the soils. In this case, we found the soils that were stipulated in the very general NRCS soil map, but we found them in different proportionality. Therefore, the majority of the soil is class 7 Gosney, and there is good soil down the southwest corner, 36A on our final soil map, which was approved and concurred with by the DLCD, that there are good farm soils down in the southwest corner comprising 6.92 acres. But the 13.44, which is a 66% preponderance, are generally unsuited for agronomic and forest practices according to USD NRCS and DLCD and Deschutes County mandates and protocols. And this is, again, I'm coming from both as a former NRCS soil scientist and a current principal soil investigator. And so I just want to make sure that we get that clear, because that's a false statement. And I don't care what county you're in or what state. An Order 1 soil survey is a very high confident interval soil survey. And we do it in all 50 states, but the NRCS does not do it. They do Order 3 broad soil survey for broad farming, broad range, and broad forestry. So they're an introduction. And just a couple more statements, I'm done. I know you're trying to expedite this, and I apologize for my laborious comments here. But I want to reiterate that we did have a letter of concurrence and soil release from the DLCD. The principal investigators there said that my work was competent, valid, and reliable. And you can check the record for that. And the second thing is, it's really important, is that the irrigation, in this case for the class 7 Gosney soil, which is a notoriously poor soil in Deschutes County specifically, does not improve the efficacy of the soil as far as capability for growing agronomic crops in this particular case. And that's really important. And you can look at page 2 of my report that went to the DLCD and was vetted and approved to show you that the lava plains have a distinct convexity and face south and west, and that potentiates the harsh conditions. And obviously, Pat has illustrated about the rocks that are close to the eastern aspect of the property. But the main thing on the Gosney soil, why it's such a bad soil, is it's topsoil free. There's no topsoil virtually on the Gosney soil. The good soil that's on the property, called the desk camp, has very good topsoil. That soil does not have it, the Gosney, and the difference is in the taxonomy, which is way too complicated for this session or any session. But the desk camp soil, which is a farm soil, true farm soil, is a mollisol, meaning mollisol means thick topsoil. The Gosney soil is basically an entasol, and it's called a passamment, and the spelling is P-S-A-M-M-E-N-T-S. And I'm not trying to belabor the point because it's extremely complex, but that means it's a sandy, it's like a sand pile. It's like kitty litter, and therefore there's no use. And plus the soil is less than 12 inches to hard lava. There's no give in the bedrock. And as far as I'm concerned, that is all I would like to say. But really, the NRCS did this original benchmark work in the 70s. I was working for the government in the 80s here in the state. The OR NACIS Guide 1 is the benchmark, and they say the main reason why capability class 7 soils, such as this soil, Gosney, will not improve to become a farm soil is because it has very low water holding capacity, less than 2 inches. And that table actually shows that. In order to qualify for capability class 6, you have to have 2 inches of water holding capacity in the thickness of the soil, which the Gosney does not. So I'd be happy to answer any questions you have, and I appreciate the time.
Hey, thank you, Mr. Kitzrow. I do not have any questions for you.
Okay, wanted to do this to wrap up then.
Is that it for the applicant's representatives for the primary presentation?
Hello, Mr. Hearings Officer. This is Pat Cleaver again. Just wanted to do a summary. First of all, it came to my attention when I was looking at the record that's online, that you can see all of the application materials, that the application itself was converted into PDF after I supplied it on flash drive originally. And in doing so, most of the colors that I added by hand, which you can do to documents now, are not there. And so I went through it and made a list of all of the figures that we were like, okay, well, you're saying that this orange is number 6 and like that, but I don't see any of that. So you're going to be quite hampered in not being able to see what I did. Also, I noticed all of the photos, even on the screen, not by printing, but just the photos are like they're all out of focus. They're very blurry, and all of the ones in the original are extremely sharp. And so what I did, this happened in the SETI's application as well, and I brought a new flash drive tonight, and I offered a flash drive to the last hearings officer on SETI, and she says, oh, thank you very much, because I definitely needed that. So I brought one tonight, and so hopefully the staff can FedEx that over to you so that you'll have that, so you can see the actual diagrams correctly. Other thing I wanted to comment was on Mr. Kitzrow's excellent presentation. He kept saying to you over and over again that the NRCS determinations, the soil types that were done in the 70s for the original planning, were done from a lot of ways, but mostly from aerial photographs. And in our first case in Nassetti, which we've given the decision on that in 2016 to you, there were just 2 or 3 main things that were decided in that case, and one of them was Central Oregon Land Watch argued that you should use the NRCS if you have it. But what Luba says is, no, you're backwards, that when you have the survey like Ms. Gary Kitzrow did, that takes precedent over NRCS. It's much more detailed. It's where someone goes out and digs holes and actually looks at the soil and does all the things that he does. So you can look at that case, and they're agreeing with what the soil scientist is saying there. The other thing in that case, it says that when you determine agricultural soil, you have to look at the soil survey that he did and to come up with that decision. So the other thing I realized, these applications are so broad and they really want to know everything about the property. And I've tried to provide that for you in great detail in the application. But looking at 1,000 Friends letter, it focuses my closing comments that this property has kind of become, in a way, almost like a ODOT remnant property. That when the land first started, it had a dirt road at the southern end, the G.W. Horner Road, which was declared a public road by the Crook County Court in 1908. And that's how you accessed it. And that was the only road there, and was part of the 160-acre ranch. And everybody just assumes that Highway 97 was always there, but guess what? It wasn't. It used to be where Bend Redmond Highway is today, and I have that in the application in detail, but it was 2 miles to the west of where it is today. And it wasn't until 1932 that ODOT decided to make a straighter cross-country road, and that's when Highway 97 was engineered and planned. And then in 1937, the actual road was built as a 2-lane gravel road. But they left Ben Redmond Highway there, and we still use it today as an alternative north-south route and to serve all the properties over that way. So then you had this beautiful north-south highway right beside the property, and you had a very, very busy road at the south that went from Tumla, which we called Laidlaw back then, all the way through Powell Butte and to Prineville. So that was the really important north-south route. It was really important east-west route there. And now the property has a road on the side, and that's when the parcels started getting really broken up. But on the other side, literally across the highway, was a gas station, a restaurant, a store, a mechanic shop. All of that was over there. So already you had the town of Centralo just literally right beside the railroad tracks to the west, and you had this essentially commercial service to the east, and then the commercial service to the west, and you started to see the beginnings of essentially a town there. And then, of course, it became the site of Deschutes Junction, and between 1998 and 2000, with the overpass, the on and off ramps on both sides of the highway, the realignment of Tumla Road to become Tumla Place, and so on. So I hope you appreciate what's happened, and then the ADT and the noise has just really, really gone up, and I have the most recent 82s, as does Joe Bessman, the traffic engineer. So on the south side of Deschutes Pleasant Ridge Road, where the industrial area is, it used to be Cascade Pumice, which was founded around 1942. And that's why we have the double tracks there for the town of Centralo, Deschutes, and also for Cascade Pumice. And that was what was there until actually just a couple decades ago, when all of the other rural industrial properties came in. And there's 57 acres of rural industrial literally just across the street to the south of this property. Antonia Setti's property, I marked it on one of the tax maps that I turned in tonight, as literally catty corner across 97 to the south west of this property, and that's 22 acres there. So you've really got a situation where, as I started with, that you've got all of the rock from the shield volcano we called Long Butte going all over there. You've got the rock spine literally going through this property. And I can't tell you, the first time I walked on the property was back in '98. And I remember thinking, whoa, this is just like solid rock here. And it is. The northern half of this property is just rock. And then the whole east side is rock. And the whole base of the canal is just almost solid basalt rock flows, which is rock that just goes sideways, and it's just like you barely need anything else to keep the water in. But then when you go to the southwest corner, some of the dirt has flowed down there over time, and there's some dirt there to grow some grass. But the rest of it, has never been used for farming, and that's why I think, especially with the noise, the location, that the best use of this property should be RI. So I think that's how we're going to close here.
Okay, thank you.
You're welcome.
I don't think we had anyone sign up to provide testimony in favor of the application, but I just want to double check that there hasn't been anyone else that's arrived in the hearing room for that purpose.
No, there's not anyone else in person. There is one other attendee online, but I don't know if they want to provide any testimony. They did not raise their hand earlier, so.
Okay.
Yeah.
Then let's proceed. We will take anyone who's signed up for testimony in opposition to the application, and it Sounds like we have one person in the hearing room. We should start there.
Good evening, hearings officer. My name is Carol Macbeth, and I'm a staff attorney for Central Oregon Land Watch. On behalf of Land Watch, thank you for the opportunity to testify. Our offices are in Bend at 2843 Northwest Lolo Drive, and the zip code there is 97703. I have been involved in a case across the road from this case, another rural industrial application, for about 10 years myself. And I totally predict that this case could also go for 10 years. This is a very complex application, and at a minimum, I think that it would require exceptions to Goal 3, Goal 5, Goal 6, Goal 11, and Goal 14. This is a goal. There are Goal 5 resources here. This is in the scenic area between Bend and Redmond, the UGBs of Bend and Redmond. There's a landscape management zone protecting the scenic views of that area. So changing the use to industrial involves having to do an EC analysis for a conflicting use, because when the Goal 5 inventory was acknowledged by LCDC, it didn't have industrial lands allowed outside of 4 specific areas. So this change in the allowing industrial zone to go wherever now means that on this particular property, it would go in a landscape management zone. And that is a conflict in the landscape management zone, the scenic resource area that's listed in the comprehensive plan. So there would have to be an EC analysis and weigh that. It's also, of course, is in the landscape management zone. It has to comply with that, which will not be simple in the way that it has been proposed here. There will need to be a Goal 14 exception. I brought 2 documents that I'll give to Caroline for you. They explain I particularly draw the hearings officer's attention to these documents. One is an ordinance from 2002, and the other is the policies in the plan today that were written in 2002. And it makes clear that what just happened across the road, this simply isn't in the ordinances. It's not in the ordinance. It's maybe about 7 pages of reading for the hearings officer. If you'll look at what happened in 2002, I think it's quite clear that it is not a rural zone. And because it's not a rural zone, one either has to take an exception or prove that this RI zone is not going to convert the land to urban uses. But across the road, they tried in 2020, they tried in 2021 and 2022 for 3 years. There was an ongoing effort to show with the Schaefer factors, they're called, that this RI zone is not urban, and they were completely unable to do it. They just weren't able to do it. It's not possible to do it because it's an urban zone, and that's why a Goal 14 exception is going to be needed. And I mean, it's going to add up. I'm just saying, I know that's not a legal criterion, hearings officer, but Goal 3, Goal 5, Goal 6, Goal 11, and Goal 14, it's really going to start to add up. The soils that matter are the soils by the NRCS. I'll just read the definition of agricultural land from Deschutes County because it's only about 7 or 8 words. Let me see. 1, 2, 3, 4, 5, 6, 7, 8, 9. It's like 12 words. Agricultural land means land classified by the NRCS as predominantly Class 1 through 6. So agricultural land, as the hearings officer knows that law is filled with terms of art. Agricultural land is a term of art. So what we run into very often and have this evening is that people believe that they know what agricultural land means. They say, this land is more agricultural than that land. I think this is good for farming, or it's not good for farming. I think it's rocky. And none of that really comes down to anything because the definition of agricultural land is a term of art. It means what it means. It means what Goal 3 says it means. It means what Deschutes County very closely says that it means. It means what the NRCS says is Class 1 through 6. And it doesn't matter what anyone else says. These are published data from the United States government in official government publications, and anyone can find it out in Deschutes County, where we have NRCS data. Anyone can find it out by looking it up either in the paper form or online, and that's the definition of agricultural land in Oregon. So all of this, and it's really, it can be very costly to get these soil science studies done. It's not a criticism of a soil science or the scientist who's working on this case. I'm sure that these people are good at doing what they're doing. It's just not legally meaningful because as the soil scientists rejected this, but the fact is that there are two parts to the agricultural lands analysis. This is the first part. It is class 3. It is class 1. It's class 3 irrigated, class 6 not irrigated by the NRCS. That's between class 1 and 6. That's agricultural land. It's agricultural land. It's 100% 36A and 38B, which are both predominant. It's class 3 irrigated and class 6 not irrigated, and that's all there is to it. But there's other types of land like that are class 7 or even class 8. Those might be agricultural land. And so the soil scientist information can be very important in that case, but not here where there is NRCS data. See, there's no question here because this is already known to be agricultural land, and the question is whether there might be other land that isn't known that could be added. So in times when agricultural land is highly valuable, and we may be coming up on one of those now, people will want to have their land included. And in that case, they may want to have a soil scientist, for example, to include their land that isn't NRCS class 1 through 6, but there is no opportunity for subtracting from that amount. Also, and we will provide a lot of information about the nature of Order 1 surveys and about the NRCS survey here in Deschutes County, but it is a little bit, it really is a distraction because, again, the meaning of agricultural land is class 1 through 6 from the NRCS. That's all it is. And in the case across the road where LUBA was confused, I believe, although of course we respect their opinion on that for that property, there was a map taken from online and it had a warning on it that said not valid at this scale. And that really not confused, I shouldn't say. It was something that LUBA focused on very much. And it just had to do with the difference between a printed document and an online document, but they didn't realize that apparently. So they were very concerned about that. That won't happen here. So I just can only reiterate that the agricultural land definition in Deschutes County, which is from Goal 3, is a very short definition. It is not capable of being misunderstood. It's a term of art. It's a matter of law. And when, in this case, across the road, LUBA looked at it as a weighing test, like, oh, well, maybe if the county wants to listen to the soils expert, they can weigh that against the NRCS, as though the NRCS were an expert instead of a published United States government document. But it's not a weighing test. It's a legal definition. It's an application of law. If it meets the definition in the law, it's agricultural land, and it's not a substantial evidence test at all. That's why it doesn't matter, and that's why consistently it doesn't matter, although it has been very, very gravely misunderstood, and it isn't just in Deschutes County that has happened. I wanted to point out that, and I will send, I would like to request that the record be open, and as part of the open record period, I will submit maps of 36A and 38B across Deschutes County, all of it in use for farming. There's agricultural fields just like right across the road. It looks like it's owned by the Oregon Distillery family. They have a nursery growing right across the road, and the NRCS says that's the same soils. So it's the same climate, it's the same wind patterns, it's the same rainfall, it's everything, and the NRCS says it's the same, and they're growing crops right along the highway. And there is no reason, and there isn't any reason why this landowner can't do the same thing. Of course they can. They just don't, they may not wish to. So that's that. There is no question that this is going to need an exception to Goal 3 because of the definition of agricultural land that is a legal definition. It's not a substantial evidence question. Goal 6 and Goal 11 are mutually exclusive here because there can't be a sewer because if you are allowing an urban use. But Goal 6, although, again, it has been said that goal 6 is complied with if DEQ will be there to add permits or something, but that's putting off compliance with goal 6 to the future. It's saying the goal 6 compliance has to be shown now, and if the applicant isn't saying what use it is, then we don't know what is going to be going into the groundwater or if there's no sewer to take it away. What are the discharges from this use? We don't know what the use is, so we don't know. And the zone allows glass factories, plastics factories, and leather tanneries, in addition to pulp and paper manufacturing. They are very intensive uses. This is a grandfathered in zone that should not even be possible to be put outside of UGB, but it is. And the limitation that we have is that each site has to be evaluated individually, and that's what's happening here. Again, after many years of trying, it was not possible to show that this zone was not urban. That's because it is urban. And I haven't seen any evidence of the Schaefer test, but then I didn't really look for it. So an EC analysis will be needed for goal 5. An exception will be needed to goal 14 unless the applicant can show that it is not an urban zone. That should take, years. It'll take years. The whole thing's going to take a long time, so we should all just settle in. And I'll be happy to provide additional information in writing. And we would, again, request to have an open record period of at least 7 days, if that would suit the hearings officer. Do you have any questions for me?
I do. I have several. You've raised a lot of issues that I don't think were in the record, or at least the record that I reviewed prior to tonight. So I just want to make sure I'm understanding your position on everything. With respect to goal 5, I didn't catch what you said. What is the inventory to goal 5 resource that's on this property?
Oh, it's a scenic view. So in goal 5, it's, usually we think of winter range, but it also includes open space and scenic views. And so for the scenic view portion of goal 5, you know how historic resources are cut, there's an inventory of those. And this is on the list as the highway north of the Bend UGB and south of the Redmond UGB, because looking to the west in particular, there are scenic views of the Cascade Mountains. So in the past, the RI zone, which is requested here, could only be put on 4 different sites across the county. And now it's been expanded and it can be put potentially on any place. So this application is asking to put it in a scenic zone. And so it's putting it where there's a goal 5 protection in place. It's protected and it's in the acknowledged goal 5 inventory. So whenever that happens, it's industrial use in general is a new conflicting use. It would be difficult, I think it may be impossible to do a zone. I think that they may have to pick an industrial use just because the goal 5 EC analysis has to weigh the costs of whatever's being proposed here, industrial use, against the benefits of the scenic views. It's very hard to imagine a scenic view with an industrial zone, and that doesn't make any sense, but that's not the point. The point is that the EC analysis itself requires it to be very specific. We have to know what it is. For example, if someone wants to put a house, then they know what that is. If wants to put a grocery store, we know what that is, but we don't know what they're going to put here. We don't know what the industrial use it is that's proposed. So I don't think that in its current form it could actually meet the requirements it would need to take into account this scenic area that is a goal 5 listed resource.
Thank you. On your remarks about needing a goal 14 exception, what is your position of the uses that are urban that are going to be allowed with this zone change?
Well, I believe, like in my heart, I believe, in other words, it's not a legal determination. It's very much up to you, that like the glass factory or the plastics factory or the pulp and paper manufacturing plants that are all allowed in that zone, that those are urban scale, urban intensity uses. But I don't know if you've worked, hearings officer, on a Schaefer test case before, but there's a set of factors that LUBA has developed to see if a use is urban or rural. And that is what was unable to be proven across the road. Very, very difficult to comply with. Actually, the same traffic engineer was on that case. they're very difficult to comply with, and it never was shown. And I think that that's going to be a difficult, I don't see why that would be easier on this side of the road than it was on the other side of the road. It ended in a it never found it, it was never true. And what LUBA wound up relying on is this ordinance 2002-126, which I just handed to Caroline House. And I hope that you can take a look at that, because LUBA has misinterpreted that. But I'll explain that in writing in our testimony.
Okay, that would be helpful if you're asking me to find something different than what you think LUBA has said. It would be nice to see that in writing.
Oh, yeah, I mean, yeah, it goes back, I think the county might have originated this interpretation, but I'm not sure. But LUBA and the county believe that this one policy, it's called 3.4.23, they believe it says something that it doesn't say, and it's really like 5 sentences long. It doesn't say that. And I mean, the Court of Appeals just issued a affirmation without opinion. We would have loved to see the Court of Appeals look at it. I tried very hard to get them to look at the language, because it's quite simple. It's a simple error, and but the Court of Appeals affirmed without opinion and did not look at the language. So we have not had any decision maker look at the language to critique the language, and I hope that you will be that decision maker, but I will try and make it as straightforward as possible. It is a very short text, and it's just a simple error in, the RI zone can mean DCC 18.100, but in this ordinance in 2002, they used that term to mean these 4 industrialized sites. And there's been it's an equivocation error in interpretation that has led to this big misunderstanding. In my opinion, it's a big misunderstanding. And I would just like to reiterate that we respect both, of course, the Court of Appeals and the LUBA decision for that case. But this is a new property with a new set of circumstances, and we believe many of the same issues arise again.
Thank you. With respect to the portion of your testimony where you mentioned the definition of ag land, and that it means land classified by the NRCS as predominantly 1 through 6 soils, I understand you're pointing to that definition. Is it your testimony that this property is predominantly 1 through 6 soils?
Yes, it's composed of 100% of 2 different soils that are in agricultural use across Deschutes County, mostly for grazing or for pasture, but also for nursery crops. And their map symbols are 36A and 38B, and I'd be happy to show that to you, but in my written testimony. But they do appear on the map on Dial, because the GIS department of the county has adopted the NRCS soil classifications, and they're available on the maps as a layer. And so according to the NRCS, it's composed, I don't know which one is predominant, but since they're both class 3 when irrigated and class 6 when not, the whole property is class 1 through 6. It's 100% class 1 through 6. And it's not, again, it's not a question of whether someone thinks that the NRCS is right. What happened is that LCDC, because the legislature was so interested in protecting the largest amount of agricultural land as the part of the agricultural land use policy for the state, that LCDC just really, really drew the line with a broad brush. They included many, many things. They included land that is class 1 through 6 from the NRCS. All of it is agricultural land. And then from there, it moves on and includes even more than that. It includes class 7 land if it could be put to farm use. It really couldn't be much broader. It's a very, very broad definition. It's very difficult to find land that is. And I think up on the pass, Mackenzie Pass, the D. Wright Observatory, that's some class 8 for you. That would be hard to say that it could be farmed, but the net is cast very wide. So that the entire discussion about whether someone thinks it's farmable or whether they think it should be agricultural land is like a substantial evidence question that isn't before the hearings officer. All the hearings officer has to do is look at the map, which we'll provide to you or which you can get on Dial, compare it to the definition, see that it's predominantly class 1 through 6.
And thank you. I understood that part of your testimony. The piece I wrote down, I want to make sure that I understand your position too, is that once the NRCS classification occurred, I think you said there's no opportunity to subtract from that. That is,
Well, the NRCS has a policy that they don't change these, unless, they come out and there's some extraordinary circumstance, I don't even know when that would happen, but their policy is that they do not change their published data, they stick with it. That's not what I mean, though. What I mean is that if it meets the definition of agricultural land, then it is agricultural land. It's just like, it's a term of art. It isn't something that, because it's not an opinion, it's a definition.
okay. And then I think the last question I have for you, you mentioned goal 11, but I didn't hear your explanation of why an exception for goal 11 is needed.
Well, if they're having industrial uses and no sewer is permitted because, well, first they have to prove that it's not urban, but goal 11 will not allow a sewer to be put in if that would allow more intensive or more urban use than would be allowed otherwise. So neither water nor sewer can be provided from a public service. It has to be a rural use. So there's a constraint that way because, again, if you have polluting industries, which some of these are, like a glass factory or a pulp and paper manufacturing plant, where is the waste going to go if it doesn't go off in a sewer? And like septic systems and that sort of thing are designed for human waste, which is organic. And they're not designed for toxic metals or whatever they have in manufacturing. It's not, you can put it into a septic system, but it's not going to protect against the contamination. So that it really, to have industrial use, you need a sewer, but goal 11 doesn't allow a sewer. So goal 6 needs you to have a sewer to take the waste away, and goal 11 needs you not to have a sewer because it'll make it urban. So those two goals are in conflict. And they would need to have exceptions to one or both of those in order to put it in because of the nature of the use. And unless the applicant, again, if the applicant will specify what use the applicant has in mind so that everyone knows what we're talking about. I mean, I think that's why the one across the road went on for 10 years is no one it's very up in the air what was being proposed. There's just a whole suite of uses in this zone. But if a particular use is picked, then we can find out what the discharge would be and, think about it from there. It's easier to get a handle on.
Okay. Thank you. That's all the questions I have.
Thank you, hearings officer.
I'll just ask for the sake of making sure we don't miss anybody, if there's anyone else online that was signed up or wanted to testify in opposition to the application, they should raise their hand on the Zoom call.
There are, Mr. Kitzrow has raised his hand, but I think we're at the point of rebuttal testimony now.
Yeah.
So.
Okay, so I think we're done with that piece, and it looks like the applicant's representative is back up at the table. So this would be the time for the applicant's rebuttal.
So hello, Mr. Brooks. This is Pat Cleaver again, doing the rebuttal. And I was surprised that I have heard every one of those arguments before. And I think you heard some pretty shocking things like, well, Luba didn't understand this. Luba looked at this one diagram that said, do not rely on it, and they relied on it and made a decision. I think those are pretty shocking things that Central Oregon Land Watch said. So one big decision that was made in the SETI case was that the Deschutes County Rural Industrial Code is an acknowledged code, and that the entire code is for rural uses. It is not urban uses. And Central Oregon Land Watch tried that argument pretty much every one of our very long, as she said, 10-year battle on this. And that has been a consistent thing. And so I just wanted to say that. Also today I emailed to the planner, Carolyn House, Stephanie Marshall's decision on the second SETI case. And that also reiterates that very clearly. But the decision on that case really held up beautifully. And there was only one part of it that Central Red Land Watch prevailed on, and that was she said that this section on employment numbers was not well explained. In other words, somebody looking at that section of the Stephanie Marshall's decision couldn't really understand where those employment numbers came from. So we looked at that, and Luba looked at that, and they said, yeah, we're going to remand it back to Deschutes County so that they can be more complete in where they got the future worst case scenario employment numbers, where they came from. And that was done. And so last summer, we held a public hearing to clarify that. And Tony's attorney wrote the decision for the Board of County Commissioners. And we added a lot of information into it about the source of those numbers. And that's what the last appeal was about. The second thing I wanted to mention to you was that we've also heard the argument that, well, they need to tell us, they need to open the secret box, tell us what horrible plastics or feather factory or whatever polluting, water polluting, smoky thing is going to be there. And unless we know that, we can't, argue against it. Ed Sullivan did a beautiful argument on a Luba case called Benjfran, Benjfran. And what he said, I really always stuck with me. And what he said was, you know what? Whenever you're rezoning a property, you cannot say, well, I'm going to rezone it to put a new used car lot here, or I'm going to rezone it to put a water park here. You can't do that, because if you rezone it for one use, guess what? The day after that rezone becomes final, that owner could pass away. That owner could sell it to another person. And we know that in history, properties are sold many, many times. And as soon as it has a new owner, you're going to have a different use. And no uses. I mean, how many blacksmiths and hat makers do we see around today? We still see a few, but not too much. Times change, the uses change. So Ed Sullivan's argument was that if you're going to rezone a property for a certain use, it's not going to be there for very long, and then you've got the property rezoned, and then somebody can come in and do whatever else the use that meets the new zoning. So you need to apply the zone without having a particular use in mind for that reason, if that makes sense to you. Also, we've heard all about the pollution of the water, the pollution of the sky. In this case, there are two houses that are within the, I think it's 600 feet of the property. And in the incomplete letter response, you'll see where we actually drew the circles from those properties onto the parcel, and you can see where they go, because that's a really big deal. Because in the code was very wise in saying that if there's surrounding properties, even with that great distance, that have a residential use, we want to throw any of the uses into a public hearing. We want people to be able to comment on the uses, and that's in the code, and it that does apply in this case. So first off the bat, it says that you can only do 70% of the normal density that you would be able to do on the RI. So right away, we went from the total acreage, we took out 2.5 acres for the canal, and then we have 100-foot setbacks because it's in this, as Carol said, the landscape management zone. She mischaracterized that. I'll fix that, but there is a zone that's very well done that says all along the highways, it's not just parcel by parcel. It's definitely not like having an historic parcel, historic property. It's the whole highway, every property there. So obviously, it doesn't take away the person's right to develop their property by a long shot. But what it does do is it increase the setbacks. Normally it would be 50 feet from the highway. In this case, the LM zone says you have to be 100 feet from the highway. So in our diagram, which is in the application, and it was revised in the response to the incomplete letter, that takes us down to 13 acres of developable land because of the landscape management zone. So already we've reduced it because of the proximity to houses, and it's thrown it in the RI uses. All of them have to go to public hearing, and that's already in the application. But now we've got this landscape management zone all along the western edge, 100 feet, and that's, down on the flat part of the land. You can't build buildings, and then when you can build buildings where you can, they have to be less than 7,500 square feet, and there's a height limitation. We have codes that have minimum distances between buildings, and of course all of the on-site requirements when you do development for a site plan development. It's going to be a very low density. So what kind of factory that's going to be an awful spewing, water polluting factory, what kind of thing is going to fit on this property in 13 acres with this bi-level property? You've got to be practical. You've got to be, real. And then my husband's a civil engineer. He's the one that drew all the diagrams for you. And he has done lots of systems, including Arenco systems, where they definitely can do on-site detention for factories, restaurants, whatever. Of course, there wouldn't be a restaurant here, but I'm just showing you that, that has a lot of grease and stuff, and they have, a lot of times when you talk about someone else's specialty, about their profession, you don't quite get it. And in this case, Central Grand Land Watch is definitely not a civil engineer, and she doesn't know what she's talking about. It's kind of like, engineers see everybody else's quandaries and problems as, hey, this is cool, let's get this done, let's figure out how to do this. So there's definitely places to do it. So I wanted to talk about the landscape management zone and Goal 5 properties, because when I was staff here as a planner, I handled a lot of Goal 5 applications. And you can't just, say, oh, well, I think this property at Deschutes Junction where the funny farm is, we're going to have it be a landscape zone, and everybody can go out and get their binoculars out and look at the Cascade Mountains. That is not how the landscape management zone works. What it does is it's along the whole highway. It's not property by property, and it tries to get so that if you're driving down the road, that you won't feel oppressed by buildings all be right up to the property lines. And so how the county handled that was by increasing the distance that buildings can be built in that area, which is like the whole distance of the highway. So it's saying you have to be 100 feet before, away from the highway, which is in this particular long, skinny property with the two levels, it's a very big area that's going to be not developed at all. Let's see if there's other stuff she said that I should let you know. Oh, in the application, I actually copied the entire I zoning code, which includes the outright permitted use as well as the conditional uses. And I think that the fact that because of the proximity of the residential, two residences there, one that's really pretty far away and one that's within 50 feet of the edge, that you are going to have to, pick up, I put that into the actual code that says that, about the 70%. But the main thing we're talking about these, really pie in the sky polluting factories that will absolutely not happen, is that you have to have a public hearing. You have to have notice of the public and all of the information that gets sent out to the surrounding property owners as well as being put in the newspaper. If something like that happened in Deschutes County, everybody would show up. We just don't have that kind of development in the county. And there are so many groups over here, including my own self and my husband, who would be at that hearing saying, no way, Jose, would we have something like this. Also in the code, it says that you cannot have things that cannot get the state permits. And you can't anymore, you can't just plunk down a factory and not get a permit. You have to have permits for all kinds of discharges. And to have the permits, I mean, the whole thing is so ludicrous. If you look at the outright permitted uses, they're actually very low key. They have a lot of space. They're definitely rural uses. And like I said, the rural industrial zoning code has already been acknowledged. And the uses are, we put together a package of uses from that permitted use list that we thought are, we looked around the Deschutes Junction area, and there's a whole table in the application that Tony Assetti and I put together last summer. We literally went, my style, we knocked on every door, we talked to every administrator or owner and all the buildings in that area. We said, what goes on here? Do you have restrooms here? Do you have septic tank here? Everything about them and number of employees they have, and that's we put in the application as well. And anyway, we've tried to be as thorough about it as possible. So when we put together this list of potential uses to figure out, what might occur there, we didn't do pie in the sky. We didn't do what Ed Sullivan warned against. We didn't say, oh, there's going to be this, there's going to be that. But the uses that we put together, we could really see who knows, we never really know, but they might be uses that were there. And they would not be anything about what Central Oregon Land Watch is afraid of. Also, when you don't have a lumber mill here, it's really kind of silly to even talk about a pulp and paper mill. Plus, if you look at the ones over in your neck of the woods in Vancouver, Washington, you'll see they're very space intensive. We don't have the space here for that kind of thing. So it's really unrealistic. Also, she spent quite a bit of time telling you about the NRCS and reading the sentence out of the Oregon code, but that's already been decided. It's old news. We've been there, done that. And what Luba consistently said, maybe she didn't like what they said, but they consistently said that when you have soil scientists do what Mr. Kitzrow did, that absolutely takes precedence over NRCS. We learned about that when, I'm trying to remember the year, I think it might have been around 2010, when DSL was the actual applicant to Deschutes County to rezone their own land, which is called the Stevens, Stevens, Stevens Tract, which is really on the east side of the urban growth boundary of the city of Bend. And that, Liz Brancher was the attorney that handled that case, and Tony Assetti and I were thinking about the zone change for his property because of all the craziness he'd gone to. He couldn't even use his property anymore since the overpass went in. And we sat through everything in that case, and we learned so much. But they brought up all these same issues. They brought up the fact that we're going to be looking at soil types and NRCS versus individual soil analysis, and they spent probably a whole day on this, and we learned all about it and what DSL itself, what their state state people preparing their application and being, their own consultants there, was that that you needed a soil scientist, and they explained how in the 70s it was, it was something that was not going to happen to have every parcel be analyzed that way. So they just went off aerial photos and based on what the NRCS, did when they did the original zoning. But when you do a property by property analysis, obviously it's going to be more accurate. Anyway, I think those are the main things, but I just wanted to alert you the fact that I did turn in Stephanie Marshall's last decision so that you can use it as well. And she refers to each of these issues by Luba case. And she says, like, in this case, we learned this. And she quotes from each one. And one other thing I wanted to say is Century Land Watch brought up about the 2002 Deschutes County work that was done. Obviously, it's been updated, and so she's going way back in time. She put together quite an elaborate argument before the Court of Appeals, and we're talking about the part of our application that in the decision did not adequately describe the source of the employment numbers. That was the issue. And when she went to the Court of Appeals, she pivoted and started in on this 2002 stuff. And you can see where that got her. They didn't even write an opinion. They just affirmed Luba's decision. And because she was so off base with that, it was like, huh? What is this all about? So again, very tired old arguments that she's trying to pull forward. And a lot of them have already been decided, and a lot of them are not even based on facts. So I think that's it. Thank you.
Okay, one last question before you leave. There was a request to leave the record open. I didn't know if that's something you were agreeable to and or wanted to request yourself. It sounded like you mentioned in your opening comments you might have additional submittals. So.
Oh, I'm sorry. Yeah, I just, that's such an ordinary thing. I just kind of assumed. But I think it's always a good idea to just to do that, as a matter of course. If anyone wants to add anything in, I'm sure Ms. House can lay out what the usual time frame is on that.
Okay, thank you. All right, that concludes all the testimony that's been signed up. I don't have any other questions for staff, but if there are any, I don't know if staff has comments that you need to make before we get into the sort of post-hearing process.
No, nothing in particular. I'll obviously work with the applicant to make sure we get a higher quality scanned copy of the materials to you so you can see all of their notes. And Central Oregon Land Watch is requesting for the initial new evidence period to be 14 days for the open record period, but staff doesn't have any other remarks other than that.
Okay. All right. I do think it makes sense to leave the record open. I'm fine doing kind of a 14, 7, and 7. I think that, well, I can calculate the dates, but I think Ms. House, you might be able to do that too. So let's make sure we have agreement on what those dates are. And then I think you probably have some instructions for how the submittals will work on those dates.
Before I get to the dates, or I can do that. Well, I can do that first, but I also want to note that the property owner has their hand raised right now. Do you want to elevate them to make sure they don't have concerns about the open record period or something else to add?
Oh, I see there now. Okay. Yeah, is there, Mr. Ruber, do you have a procedural question? Maybe he has to be elevated.
They're working on it right now.
Okay.
There we go. I was wondering if you would accept a couple comments on Carol's testimony.
Well, I guess as the applicant, I don't want to prevent you from making a full rebuttal. Is it in addition to anything that has already been said in rebuttal?
Yep, it's pretty short and sweet.
Okay.
About 3 minutes.
Sure. Let's see if we can do it in 2.
Okay, here we go. So when Carol is trying to set everything up where we have to pick uses before it can be approved, that is absolutely impossible unless you can find one use to take the whole site, because she's setting this up on a catch-22. Most of the uses are smaller uses or only a portion of the property, and those would have to be approved individually by the county, but we can't break anything up and sell it to them until it's rezoned. So we can't apply for a small use until it's rezoned, but she doesn't want it rezoned until we name those small uses. And to get enough people on there to break up 20 acres and have everything occupied all at once before we can start is ludicrous and a catch-22 of the first definition. A lot of the things I've had inquiries about are warehousing, RV storage, lumber yards, sawmills, landscape companies, and a motorcycle club, of all things. So as far as her worried about manufacturing, the county has a specific list of what's permitted in an RI zone. I'm sure they'll enforce that stringently. DEQ monitors discharges, whether it's septic systems, air pollution, whatever. She doesn't have the resources are not available to put in a pulp or paper mill. They take a tremendous amount of water. It's just not there. So her argument is nothing but a red herring and just a total head fake on her part. So anyway, if you take a look at that catch-22 situation and realize what she's trying to set up, I mean, attorneys have a job to oppose something if they're paid to, and she's doing a very good job of throwing stuff at the wall. Unfortunately, I think first week of law school, they let you know that truth is optional. Thank you.
All right, thank you. We'll conclude all the testimony with that then. Now, Ms. House, do you want to go over the dates in the process?
Yeah, and just to confirm, you said a 14-day new evidence period initially, then a 7-day rebuttal, and a 7-day period for the final argument.
Correct. Okay. And I'll go over some limits on that once you're done.
Okay, so then the dates would be for the deadline for new evidence and testimony would be Tuesday, April 4th at 4 p.m. The rebuttal period deadline would be Tuesday, April 11th at 4 p.m. And then the final argument, which only the applicant can submit materials for, would be April 18th at 4 p.m. And while I have this up, I'm just going to run through one more slide, which is, so any submittals need to be submitted to me directly. My name's Caroline House. Again, my email is my first and last name @deschutes.org. And the county does not take responsibility for retrieving any information from a web link or a cloud storage service. And then this has come up recently. Any electronic submittals, we do take paper, but electronic submittals need to be received by the county server by 4 p.m. So if I get something at 4:01, it likely won't be considered for the record. So please, don't cut it to the last minute. That's all I had.
Okay. Thank you. So I'm going to go over those dates one more time. So I'm going to close the hearing right now. It's 8:16, but I am going to leave the record open, the written record open, and the first period that's going to be open, I'm going to refer to as the open record period. That'll be open until April 4th. And then subject to the instructions Ms. House just gave about the time period and where to send submittals. That's open for all parties to submit information. The second period that I'm going to leave the record open goes from that date until April 11th, and that's the rebuttal period, and that's for any party to provide evidence or argument that rebuts what is provided during the open record period. And then the final period is going to be from then until April 18th. That is for the applicant only to provide a final legal argument with no new evidence. With that, I'm going to go off the record, and it is 8:17. Thank you.
Thank you.